to be talking about disputes, all forms of different types of disputes that occur, landlord and tenant, debt matters, family disputes, inheritance, textile matters, design matters, trademark matters, all sorts of different types of disputes we're going to talk about today. Just a reminder about the phone line and the WhatsApp line. So if you want to phone in, well, firstly, it's 87.7 FM. If you want to phone in, the studio line is 0116 4822 086. If you want to WhatsApp, 0774 885 5055. So I've got my colleague Yusuf with me today. Yusuf, one of the things that is quite common, especially with the pandemic, is that there is a lot of people, companies and individuals who are owed a lot of money. And often you get different situations of where people say they're going to pay, they don't pay, or they start to raise dispute. What's the process? Someone comes along and says they're owed, say, £35,000. What happens next?
Well, usually we will take details of what the dispute is regarding and why the money hasn't been paid. First and foremost, what we need to do is a letter before action, which we write to the other side, providing them with 7 or 14 days to repay the money. And if the money's not repaid, then we then look to take court action.
Can I interrupt you, Yusuf? What if someone actually says to somebody, I do owe you the money, and they say they've had a text message, but they don't pay? Do you still have to go through this letter process?
You do still have to go through the process of a letter before action, just to cover yourself for any criticism you may face by the court if the matter proceeds. Just on that point, we've actually dealt with one, Rafiq, recently where a client came to us to say that he's owed a sum of money by another company. The other company had messaged a few times to say, I admit I owe the money, but it just wasn't forthcoming in terms of payment. We then got involved. We sent out a letter before action, and that created a positive response. The company immediately called me up and said, look, I apologize, I owe the money, I just need a bit more time, can I have 7 days?
So what's the difference? So if you've had a text message or somebody's actually told you face to face that they owe you the money, why isn't that good enough?
It's difficult because obviously in the trade, as the listeners will be aware, you get a lot of false promises. And this particular client came to us and said, look, I've had a number of promises. He's promised me so many times. He's promised me over the last 6 months that he's going to pay the money, but he just hasn't done so.
Okay.
I actually got a response. The person who owed the money actually said to me, Yusuf, had you have not written to me, I'll be honest with you, hand on heart, I wouldn't have paid this money even though I know I owe it, I wouldn't have paid it. Because you got involved, I ended up paying it.
Okay. All right. So now we've sent the letter then. So tell us the next step. They've either responded saying that they don't owe the money now, or they don't respond at all. What do you do then?
Well, if they don't respond at all, then our client's got a decision to make in terms of whether he wants to start court process to recover the money. Now, that's a form of court claim to recover the money that's owed to our client.
Let me stop you there. We've heard in some places something called bankruptcy or winding up a company, and then there's obviously the court process. Can you briefly tell us what's the differences? Because sometimes courts can take, especially with a pandemic, 9, 12 or 18 months. Tell us about that.
The court process can take longer than a winding up process, but word of caution, in terms of winding up process, that should only ever be used if there is no dispute to the funds or the sums owed. Because if there is any form of dispute, then the courts are unlikely to grant a winding up process. They're unlikely to grant the statutory demand.
So is the bankruptcy and winding up more kind of for paper cases, is it?
It is. It's when there's no genuine dispute, when somebody owes the money completely, has no dispute at all regarding any of the goods that may have been purchased or any of the issues regarding the supply. If there's no dispute whatsoever, then a statutory demand process can be quicker and, in theory, can be cheaper as well.
So let me give you a scenario then. So there's two businesses that are doing business together, and one says to the other, look, I know I owe you the money, but look, just give me a bit of time, please, because I just can't pay. Business has been a bit difficult. The letter goes out, and suddenly the letter comes back saying, well, actually, there is a dispute. The goods weren't very good, the goods were late, and you actually owe me money. What happens then?
That's a potential counterclaim against your client. So what you would look to do, you'd look to flesh out what the dispute is and what the issue is with the goods, why the issue wasn't brought to the attention right at the start, why they've waited so long to raise this alleged issue with the goods. But that's intimating that the other side might be looking to make a counterclaim against your client if you did process legal proceedings.
But why? How can they do that? Because they've told the other party that they do owe the money. They've said it verbally, admittedly, but now they're turning around and making something up. How is that allowed? Isn't that a case for a winding up for bankruptcy?
It could be, but it would be determined by a judge on whether there, in his or her opinion, is a genuine dispute. Like I said, the problem with statutory demands is if the judge deems that there is a genuine dispute to the money owed, they are very unlikely to grant a statutory demand. They would then ask you to deal with the matter in court.
What if, for example, you had an email back saying, look, I know I owe you the money and just give me some time to pay? Would that make any form of difference?
You would use it as evidence that the money is owed and there is no genuine dispute, and this now alleged dispute is just being kind of made up at the last minute to avoid these proceedings. So you would use that as a form of evidence for the statutory demand.
Okay. So thank you, Yusuf. Just to recap for listeners, this is Ramadan FM 87.7 with Rafiq Patel and Yusuf Kola, litigation lawyers, just running through the various situations that happen in terms of debts and how we deal with those. So Yusuf helpfully explained that the first part is to send out a letter. Then now we're talking about the different types of court cases. Yusuf explained if there's no dispute, then you can apply a lot of pressure by going for bankruptcy or winding up. But Yusuf, if there is a dispute, even though it may or may not be, very strong, you then talked about court. Now, does that mean everyone has to turn up to court on the first day as soon as you lodge it? What happens then?
No, you don't. So we would start the court process for our client. That's by issuing a claim form. The defendant, so the company who owes our client the money, would then become the defendant. They would initially have 14 days to put forward a response. If they put forward a response within 14 days, the courts grant them a further 14 days to put forward a defence. Now, that defence would then determine their argument as to why they don't, in their opinion, they don't owe the money.
Okay. Yusuf, just a reminder, if you keep quite close to your microphone for listeners. So you explain to us then the process. You do a letter, you start the court case. They've then got to put together basically their defence. What happens after that in terms of the next stage of the case?
So if it's a formal valid defence, then the courts would then treat it as a defended matter. So it goes into the court process. The court would then send both us and the defendant a document to fill in, which essentially puts our views to the court as to how the court timetable and how this claim should be treated. We then put forward our proposals, and the court would then look to implement those proposals in terms of a timetable for the dispute. Okay.
What's the next stage in terms of, say, documents or witnesses and things like that?
There's things such as disclosure and witness statements. So disclosure is you would need to provide all documents that are important in the matter or relate to the claim, whether they are to your benefit or to your opponent's benefit. And it's a duty by the courts on disclosure. And if you don't comply with that, so for example, if you think, oh, these two documents are going to hinder my claim, let me get rid of them, the courts will come down strongly against you on that.
So what, are you actually saying that if there's a document that doesn't help your case, you still have to produce it?
You do, yes. That's the duty of disclosure. You still have to produce any and all documents, even if they do hinder your claim, they still have to be produced.
So let's just talk about that stage then, because I'm sure in all court cases, the other side are never going to give you something that actually helps your case. What would you do if there was a document that you gave to them which you can't now find and they don't produce it? What can you do about it?
Well, you can inform the court and you can make an application for specific disclosure of documents. If you know that you have a document or you had a document in your possession which was sent to the other side but you no longer have a copy of that, then you can make an application for specific disclosure of the documents.
Okay. Let's talk about documents again. Obviously, now we're on to text and WhatsApp and all sorts of communications other than email. What happens with that? What if you've got some crucial messages on your WhatsApp? What happens with that?
What we tend to do is we tend to ask for transcripts of all communications that the client has had with the other side. So any texts, WhatsApps, any email communications, we ask for them to be disclosed to us so we can keep them for safekeeping in the event that they do need to be disclosed to the other side.
Okay. All right. So what about witnesses? What happens now? Is it, do witnesses give evidence at court? Do they do it on paper? What if they don't turn up? What happens?
Initially, all witness statements need to be provided on paper. Now, the courts generally have a rule where if you don't submit a witness statement on behalf of an individual, they generally aren't allowed to give that evidence at court. So a witness statement is a crucial part of the claim.
Okay. Let's say we hear this from time to time that a witness is not prepared to come forward because they're too scared, they're a bit intimidated, they don't want to get involved. What can you do about that?
Well, you'd have to question how important that witness is, because obviously what you don't want is what we term a hostile witness, where you call a witness in support of your claim who then turns around at court and provides information against you which is damaging to your claim.
Okay. So what do you do then? A witness says, look, I know that I heard X, Y, and Z say that they owe you the money, but I'm not going to turn up unless you give me some money to do that. What's the situation there?
Well, you can ask the court to provide a witness summons, and the court can actually summon the witness to attend court to provide that evidence.
What if they turn up to court and then completely turn around and say something different? What happens then?
Then you would ask the court to treat them as a hostile witness.
Okay.
Because they've essentially gone against their witness statement, or they've gone against the information that they provided to you.
Okay. So thank you very much, Yusuf. Yusuf has just explained the process of pursuing someone in court. So this is Ramadan FM 87.7, Rafiq Patel, Yusuf Kola from the litigation department of our firm. What Yusuf was explaining is that if you're owed money, what are the steps that you have to take in terms of trying to get that money? He talked about evidence in terms of WhatsApp, text, trying to get things in writing. If that doesn't settle it, then you write a letter. If not, then you go to court. And he explained the processes of starting the case, a defense, questionnaires, documents. He said an interesting thing about documents, which is you actually have to supply documents which don't help your case. And then he talked about witnesses and giving evidence. So, Yusuf, thank you for that. I understand we've had inquiries in terms of designs, trademarks. We know with the internet now, there's a lot of food places and design places going up. And unfortunately, there's a lot of copying going on. Yusuf, do you want to say anything about that?
Yes, we've had a few queries regarding businesses setting up other businesses with very similar names to your kind of popular businesses. So they're trying to piggyback off the goodwill and the reputation of a particular business by setting up one that's very similar with a very similar name. What can be done to protect that, Rafiq?
Okay, so as we know, with the internet, social media, more and more businesses are using that as a form of advertising. And you're right, unfortunately, all your hard work in terms of your design, etc., you find that appearing somewhere else in the country. And because we are now on the internet, location doesn't matter. Someone can take your design and start selling somewhere else. Now, what we have to look at, Yusuf, is that your design, I appreciate that it might be your design, but if it is readily available already on the internet, then it may not constitute what's called intellectual property. So if I take an example of I don't know, a black and white check tablecloth. If you go and produce that as a design, it is readily available already everywhere. So if somebody else did the same, it wouldn't make a difference. So your design has to be unique. Now, let's talk about unique. If you have a design and it's going to confuse the public, for example, Marks and Spencer, and you put Marks and Sparks, that is going to confuse the public even though it's not the same. And Marks and Spencer can then step forward and bring an action against you to tell you to stop using it. So the test generally is, does it confuse the public? In terms of designs, they're a bit more difficult because obviously they're very artistic. They may be very similar to something else. And there is a process where you can actually get a design right. You can actually register your design right. And the property office will look at your design, see whether it's unique, and then see whether they want to give it protection of a design, because that then tells the public at large that you have a protected design. And if somebody copies it or copies a major part of it, that becomes an issue. In fact, what's quite interesting, Yusuf, is that Cadbury's has managed to have a copyright for its unique purple branding, because it's known so well for its chocolate and its wrapper that you can't use the same color in terms of chocolate. So the key is, does it confuse the public? You asked about what steps can be taken. If it does, you start off in a similar way that you explained. You write a letter to the other side. Normally you ask them, please stop doing it and pay some money for your legal fees and return or destroy all items with the mark on. That's the first step that you'll take. If that doesn't work, then similar to what you've said, is now time to start a court action, which can be expensive, but they are necessary. And we've had a number of cases where someone actually went and used a very similar name, which did confuse the public, or that's the argument that our client made. And they'd fitted out their shop, they'd done their sign, they'd done absolutely everything. And our client won the case and is now forcing them to remove all their signage and remove everything. Now they've come along, interestingly, and said, will you please allow me to carry on just in that particular town? I won't affect your business, which is somewhere else. But actually now it doesn't matter where you are, because of the internet is not location based. It will still affect our client's business here in Leicester, even though their business is up north. So I hope that answers that question. So one of the things that happens on a regular basis is when sadly a family member passes away and there's property involved. And as we know, the prices of properties now compared to 20 or 30 years ago, when they were about 10 or 20,000, are now 200,000. What people are finding is that they don't know whether the deceased had actually prepared a will, and they're finding that properties are being transferred to other family members, cousins, even immediate family members, brothers or sisters, and they don't really know what to do when they were actually entitled to it. They're finding out much later on. Is that a kind of scenario that you're coming across in terms of instructions?
It is, Rafiq, unfortunately. I used to work with somebody who mentioned to me something that's always stuck in my mind. They've said grief and money does weird things to people. Now, when people sadly pass away and people are grieving, but there is money involved, then that does even further stranger things to people. We have had issues where properties have been transferred to other family members without kind of consent or agreement from the people who actually are the beneficiaries of the estate of the person who's passed away. I mean, which is why we always suggest at Bond Adams is to get a will in place whenever you have a kind of life-changing moment, or if you have properties. I know it's something that you don't want to think about, kind of issues that happen post-death, but it just saves a lot of hassle, a lot of grief for your family members if you have written down in a will your actual wishes post-death.
Yusuf, can you just explain for listeners, what do you mean by a will?
A will is a legal document which establishes a person's wishes after they die in terms of property or money or any assets that they own, or how they wish for those to be distributed. Now, at Bond Adams, we can actually do both Sharia-compliant wills as well as English legal jurisdiction wills. So if people are concerned that, if they come to us for a will, they may not be Sharia-compliant, especially in the month of Ramadan, rest assured our wills and probate department are specializing in Sharia-compliant wills. So that's something we can look to do for our clients.
Okay, so it's basically putting everything down in writing. But what happens if you, say, make a will at the age of 40 or 50, you then go on to hopefully live much longer than that, and you decide to change your mind? What happens then?
You can always draft a new will, as long as the latest will that you've drafted is legally compliant. That is the one that takes precedence, and that essentially replaces any existing will, any will that you did when you were younger. The new will that you do will automatically replace that.
So I want to interrupt you. I know you spoke about issues that can happen for your family members and things like that, and I just want to run through a few scenarios with you, if you could help us with this. We get a number of inquiries whereby someone's passed away, and then someone will come along and say, usually a family member, of course, that how did they manage to make a will when they were actually suffering from dementia at the time of the date of the will? What does that mean?
That, Rafiq, essentially means that somebody is questioning the validity of the will, and they're questioning whether the individual who made the will at that time had the mental capacity to make the decision of what they've put into that will.
What do you mean by mental capacity?
Essentially, they need to have the means to understand what they're putting down into their will. So they need to have the mental state where they're not suffering from any mental condition or mental illness, and they know exactly what they're actually stating, what they're putting in their will.
Okay, so if somebody did have dementia, which is a recognized mental illness, at the date of the will, what happens next?
Well, there are measures in place where the solicitors who are drafting the will essentially have to do tests which establish whether a person has the mental capacity to put that will in place at that time.
Okay. So, but is it fairly good evidence then that the person did not have capacity if they had dementia or Parkinson's or something like that at the time of the will?
Well, if the dementia would question the validity of the will. I mean, a mental condition or mental illness which affects an individual's ability to understand the decisions they're making would question the will itself.
What about family members come forward and said, well, they don't have Parkinson's or dementia, but they did forget things very often. They forgot their name. How were they able to make a will? What would happen in that situation?
That would then result back to the test I mentioned when drafting the will. I mean, being forgetful, we all forget things. I mean, I'm 41 and I forget things every day.
Okay.
That doesn't mean I have dementia. I mean, dementia is actually a mental illness which has been diagnosed by a clinical physician rather than just being forgetful.
Okay. All right. There's something else that arises in terms of inquiries that are raised when someone passes away. So a typical scenario is that mother or father are still alive and they're living with, say, one brother or sister, and lo and behold, when you get the will, everything is left to that person. And the other brothers and sisters come along and say, well, that's absolutely ridiculous. Mom and dad told me that we were going to share everything equally. But but I'm sure they were influenced by this person who was living with them, because obviously they were there every day. How does that work?
That's a very common occurrence that we deal with. I mean, it's one of the biggest disputes we have in terms of when a person passes away, especially if they're living with one sibling. It's why has that one sibling been left with everything, whereas the other siblings haven't? And that's where you have to question and query the actual wishes of the parents. You would do your investigations, make your investigations into whether the will is actually valid, whether those genuine concerns are legitimate. Unfortunately, it can ultimately lead to a court case.
But let me ask you this, Yusuf. If there's a will that's been prepared by a solicitor's firm and everything's gone to one person, how is it possible to even try to challenge that?
Well, if like I said, if you're grieving and you think you've been left out of a will, there's always that inclination to challenge something, even if it's a watertight will drafted by solicitors, all the necessary checks have been in place. You always have people questioning.
Okay. One of the other inquiries that we've come across at the firm is that when checking the bank statements of the parents who have sadly passed away, they find that the person who's had everything left to them was receiving money from them prior to their death. What does that kind of alarm bells?
That does ring alarm bells, because especially if it's cash withdrawals prior to a person's death and it's being withdrawn by the individual who's then benefited ultimately from the will, you then question why those payments have been taken, under whose authority, what influence have they had on their parents in terms of those withdrawals, what are those withdrawals for, what's happened to the money, why is that money being withdrawn every single day, especially in the day and age we live in now, Rafiq, where a lot of our transactions, they're not done by cash. Why are these cash withdrawals being made?
Okay. Thank you very much, Yusuf. I'm just going to recap that section. It's Ramadan FM 87.7. Rafiq Patel and Yusuf Kola from the litigation department of our firm. So we were talking about debts, and Yusuf spoke about the letter before action that first has to go out. He then spoke about a court action. We then spoke about how there's common stealing of designs now on social media and people using your marks. And then he spoke about probate and how people have been giving away assets to others, which may seem unfair, and how do you go about challenging that? He spoke about if a person had dementia or Parkinson's or some other illness at the time of making their will, could that be challenged? And now we're going to just discuss one quite common issue that's arising, is evicting tenants. Especially, we've just come out of COVID. There were probably some freezes on being able to remove a commercial tenant, but landlords equally have been suffering in terms of loss of rent. So give me a scenario, Yusuf. We've got a lease. It's got various provisions in which you can talk to us about in terms of whether you can remove a tenant without going to court. Tell us if that is possible in a commercial lease.
It is possible, Rafiq, provided that the lease has been drafted correctly. I mean, what we tend to find a lot, especially in our community, especially in Leicester with the commercial tenancies, is where a lot of landlords try to draft leases or enter into a lease agreement themselves without getting a solicitor to, at the very least, review the lease. And that leads to a lot of problems when it comes to looking to evict the tenant. If a landlord wants to take back a property when a tenant hasn't been paying rental income, there needs to be what we call a forfeiture clause in the lease itself. That forfeiture clause allows the landlord to enter the property, essentially take back the property if there's a certain number of rental payments where the tenant is in arrears of.
Okay, so that's very helpful. You've explained if there is a lease. As you've said, unfortunately, when landlords, tenants are doing business, sometimes it's done on a handshake in the community. Nothing's in writing. So we've got a typical scenario then, that tenant's not paying rent. There's nothing in writing. Obviously, they've been paying rent at some stage. What happens then in terms of trying to remove a tenant?
Well, with the prohibition on evicting tenants for non-payment of rent coming to an end under the COVID regulations, if there was no forfeiture clause in the agreement, and if a landlord and tenant have, like you say, done it on a handshake, tried to do it themselves, unfortunately, you would then need to go to court. You would need to provide a notice to the tenant to quit the property. Usually gives them about 30 days to vacate. If they don't vacate after the 30 days, the landlord is left with no alternative but to commence court and eviction proceedings.
Okay, so how long do those court proceedings take if you're trying to take a tenant out?
Unfortunately, at the moment, with the court's backlog for COVID taking a very long time, you're looking at least 6 to 7 months with the backlog at the moment.
Sorry, Yusuf, go on.
So all of that could have been avoided simply if the landlord had kind of come to a solicitor's firm to draft a legally binding lease agreement.
And what happens in that time if the tenant doesn't pay in that 6 to 7 months as well?
You're looking at the landlord not receiving any rental income. I mean, what you would need to do is once the landlord has got the property back, you would try to look to then recover the unpaid rent as a debt claim against the business or against the tenant itself.
I assume that problems could arise if the tenant's not paying in the first place and you're now trying to chase for 12 months rent, then that could cause an issue.
Well, yes. I mean, an even bigger issue than you would when trying to chase normally, because if you as a landlord have then got your property back and the means of where this tenant is doing their business is no longer there, you're then looking to recover 12 months of rent from a business which may no longer be trading effectively.
So would you say the key is to make sure that you have a proper lease and all the documents in place when you're giving a property to a landlord, and equally for a tenant to make sure that you've got a proper lease in place so you're protected?
Most definitely. I mean, people think the lease agreement, they may have reviewed what we've just said and thought it's purely for the benefit of the landlord getting a lease agreement in place. But no, you're right. The tenant is equally as beneficial to get a lease agreement in place because it provides them a security of tenure as well. If they want to carry on trading from that premises, a formal lease agreement would allow them to do that.
Okay. So Yusuf, thanks for that in terms of trying to remove a tenant for rent, but tell us about something else. It's to do with repairs. We've seen many situations where the landlord at the end of the term then serves something called a schedule of dilapidations, which is a very long word, but a very scary word, as we've seen some of these schedules demanding around £100,000 from a tenant. What does that dilapidation schedule mean? And equally, one of the things that's been arisen is a schedule of condition. So tell us about that.
The dilapidations is essentially a fancy word for saying the state of the property itself, so the disrepair of the property. A landlord is entitled to, at the end of the tenancy, to receive their property back in the same state as they leased it out in the first place. So if, for example, a tenant has been in the property for 5 to 10 years, not carried out any maintenance or any repairs of any issues that have been ongoing in those 5 or 10 years, imagine the state of the condition of the property that they hand over back to the landlord after 10 years of not carrying out any repairs. So the landlord is entitled to look to recover or be recompensed for the essentially the repairs or the property kind of being in a state of disrepair by not the tenant not carrying out any of those ongoing maintenance.
But Yusuf, sometimes some of these schedules are quite ridiculous. You know, you're talking about £100,000. They putting the top painters that you can think of, all top quality works. When you took over the property, it wasn't in a pristine state anyway.
Well, the landlord isn't entitled to what we call betterment, so he's not entitled to have the property in a better condition than when he leased it out. And that's why a formal lease agreement is very important, Rafiq, because you would highlight what the repair covenants and conditions are in that lease agreement, where it would clearly state what the tenant is responsible for and what the landlord is responsible for.
Okay. All right, thank you for that. So that's on dilapidations. Yusuf, I understand we've had a few inquiries on the subject of franchises and franchising. Tell us about that.
Yes, obviously franchising at the moment is a big thing, because you can open up a business with effectively having already got goodwill and reputation. But a lot of, similar to the previous question, a lot of stores kind of open up with very similar sounding names. How does that occur, and what is involved in terms of the franchising process?
Okay, so the word franchise comes across quite often now, especially with a lot of businesses who have a number of different branches. And for example, if you take KFC, if you want to open one of those, then you have to buy a package, you have to pay a certain amount of money, you will get a franchise pack, and basically everything you have to do, which is very different to doing your own, is everything has to be the same. So the shop kit out has to be the same as every KFC store. The electronic EPOS till has to be the same. The menu has to be the same. Where you buy the items from has to be the same. As I said, the menus, the uniform, absolutely everything has to be the same. And then in addition to paying up front, you'll pay something called royalties, which is that based upon the sales that you make, you will then pay an additional sum on top, which might be a small percentage. And then after that, then you might pay an advertising sum as well, because KFC will obviously advertise all KFCs. So there's a number of different steps. It's very important that whichever franchise you look at what they actually own. So do they own the trademark to their brand? If they don't, then you could find that a number of those marks are available, and therefore you've got to ask yourself, what is the point of spending money buying a franchise when you could simply use that money to do something yourself with a slightly different name? Obviously with KFC you can't, because that's a trademark, but that is the nature of franchising, is be very careful about what you are actually buying.
Just on that, Rafiq, you said, why, for example, if I was interested in opening up, say, a fried chicken place or a burger, why would I look to a franchise rather than just opening up my own shop?
Okay, so interesting question. It's in terms of leverage and sales. So for example, if you try to open a fried chicken shop and you had it by your own brand name, yes, you could go on social media, you could go on the internet, you could contacts with local customers, businesses, do as much advertising as you can. But are you going to take in as many sales as, say, Kentucky Fried Chicken, KFC? Because that has been known as a brand. The product is known, the product is tested, the ingredients are tested, the quality is tested. So you've got to ask yourself the question, is it worth spending that amount of money for that brand? And it is a considerable amount of money. Or you're right, why don't you spend that money doing it yourself? I think the uptake will be slower in terms of getting people in. But you have to ask yourself, in the long run, will you be able to achieve as much? So interesting question, but yes, it's based on your own personal abilities, marketing your product, and things like that. So in fact, franchising may become less important in the future, because individual businesses may as well set up on their own and then just run their own businesses in the best way that they can. And then you're right, is the consumer going to travel all the way to KFC when they've got a perfectly good fried chicken place nearby? So locality makes another difference as well. So I'm just going to recap, as we've got 5 minutes to go. It's Ramadan FM with Yusuf Kola and Rafiq Patel, solicitors, lawyers from Bond Adams. Studio line is 0116 4822 086 and WhatsApp is 0774 885 5055. I'm just going to recap what we discussed today. So from the litigation department last week, we had Ibrahim Kadri from the conveyancing and property department. Yusuf Kola spoke about the debt process if you're owed a debt, and we spoke about where debts are admitted. He spoke about sending a letter and then starting a court action and the processes. We also discussed commercial tenants, commercial landlords, why it was so important to have a lease in place. We then spoke about a very interesting subject, which is that with house prices what they are now, when sadly people are passing away, they're finding that houses are going missing or being transferred, and what can be done about that. And also there's a lot of influence now on older people in terms of where they place their properties, because they're now a very significant sum of money. Whereas 20 or 30 years ago, you could buy a residential property for £30,000. That's impossible now. And that our firm has seen so many different inquiries about that happening. We then spoke about dilapidations and why it was important to get a lease in place in terms of repair. And spoke about COVID regulations in terms of trying to wind up a company and things like that. We then spoke about trademarks and people stealing each other's trademarks, going on the internet, trying to find something very similar. And what's the situation with that? Can you simply just now open whatever you want and really it doesn't matter in terms of registering a trademark, or does it? And then that moved us nicely onto franchising. And Yusuf asked a very interesting question about why should we spend so much money getting a franchise when you can put all that money into something yourself. And it was talked about leverage and advertising, and would you travel so far to go and get some food, or would you go to somewhere perfectly local? So quite an interesting question. Yusuf, with literally 2 minutes to go, anything you want to say about the range of inquiries that you're receiving and what type of themes are coming out?
Yeah, I mean, we in our dispute resolution department, we as you know, we get a wide-ranging number of inquiries. We get inquiries ranging from kind of employment matters, or somebody needing a bit of assistance with an issue they've got with their employer, or a dispute they've got ongoing with their employer, to people owed millions of pounds from the big companies where they're struggling to recover from, even down to simply my parents had a will. I've been left out of this will. Can you tell me what's going on? It's a wide ranging number of disputes we've got at the moment. Nothing is kind of set in stone in terms of the dispute resolution department and the disputes that people are getting at the moment. It's just completely wide ranging.
I think one of the things that Yusuf, you were mentioning is that try to do things in writing if possible, because it was interesting what you said, that somebody can say to you that, yes, I owe you the money, bear with me, please, I'm going to pay you, but then suddenly you still have to write a letter. And Yusuf was explaining that, unfortunately, if the admission is not made in writing, then people sadly do turn around, and when they're in financial difficulties, they do turn around, they make life difficult, and therefore try to do business in writing. Yusuf spoke about handshakes and doing things on a handshake, which is fine. You can have the handshake, but still then go on to put something in writing so everyone knows where they stand. Is that a fair comment, Yusuf?
Definitely, yes. Especially now.
Yusuf, I know you litigators like to talk, so you've got 45 seconds.
What we would always say is, like Rafiq said, get it down in writing. Verbal communications are great, but they're not binding, and people will turn around and say, I never said that. So get things down in writing, any agreements in writing.
Okay, so that's really good. Last week we spoke about property matters with Ibrahim Kadri. This week it was on debt litigation and commercial disputes. And next week we're going to have our family law team in talking about divorces and sadly children contact cases and financial disputes in divorce, because unfortunately divorces are on the rise. And with 5 seconds to go, thank you very much. We'll see you next week.